Good day everyone, I'm Casia and my presentation is all about sections 23, 24, 25, and 26 of corporation law. Each stockholder or member of the corporation shall have the right to nominate any director or trustee who possesses all of the prescribed qualifications which Ms. Alisa Cartin discussed, and none of the disqualifications which is I will discuss later on. But the exception is when the exclusive right is reserved for holders of founders' shares. Section 23. At the end of this section, as provided under the revised Corporation Code, the elected directors or trustees shall perform their duties as prescribed by law, rules of good corporate governance, and by laws of the corporation. And when it comes to the requirements of elections, first, the owners of the majority of the outstanding capital, or if there be no capital stock, at all elections of directors or trustees, there must be present, either in person or by representative, authorized to act by written proxy, the owners of majority of the outstanding capital stock, or if there be no capital stock, wherein the non-stock corporation, a majority of the members entitled to vote. When so authorized in bylaws, or by majority of the board of directors, the stockholders or members may also vote through remote communications or in absentia. When the shareholder's physical absence, he or she may still be allowed to participate in a meeting or voting through remote communication such as video conferencing, teleconferencing, or other alternative modes of communication that allow them reasonable opportunities to participate. Number 3, the election must be by ballot if requested by any voting stockholder or member. The fourth requirement in election of board of directors or trustee, in stock corporations, the total number of votes cast shall not exceed the number of shares owned by the stockholder as shown in the books of corporation, multiplied by the whole number of directors to be elected. The stockholders entitled to vote may vote such number of shares for as many persons as there are directors to be elected, or he may accumulate said shares and give one candidate as many votes as the number of directors to be elected, multiplied by the number of his shares shall equal, or he may distribute them by the same cast. However, that no delinquent stocks shall be voted. Number 5, in stock corporations, the members of non-stock corporations must cast as many votes as there are trustees to be elected, but may not cast more than one vote for one candidate. Members of the non-stock corporation which have no capital stock may cast as many votes as there are trusted to be elected, but may not cast more than one vote for one candidate. Lastly, the nominees for directors or trustees receiving the highest number of votes shall be declared elected, meaning the nominees or candidate for the director or trustee receiving with the highest number of votes shall be declared elected. Methods which may be resorted to by a voting stockholder. The straight voting. Every stockholder may vote such number of shares for as many persons as there are directors to be elected. For example, A owns 100 shares of stock in X corporation. During the meeting for the purpose of electing 5 directors, he may cast his vote by giving each of the 5 candidates 100 votes. Hence, he distributes equally his vote without preference. The same rule applies to elections of the Board of Trustees in the non-stock corporation, whereby A has 1 vote for each trustee to be elected. cumulative voting for one candidate. A stockholder is allowed to concentrate his vote and give the candidate as many votes as the number of directors to be elected multiplied by the numbers of his shares shall equal. For example, if A owns 100 voting shares and there are 5 directors to be elected, A is entitled to 500 votes, which he may communicate by giving it to candidate number 1 alone. Number 3, cumulative voting by distribution. By this method, a stockholder may accumulate his shares by multiplying the numbers of his shares by the number of directors to be elected and distribute the same among as many candidates as he shall see fit. For example, as in the same example I've said, if A owns 100 voting shares and there are 5 directors to be elected, A is entitled to 500 votes, which he may distribute to candidate number 2 or number 3, giving former 300 and latter 200, provided that the total number of vote cast by him does not exceed to 500 votes. Let's talk about the section 24, the corporate officers. Immediately after the elections of the board of directors or trustees, the directors of a corporation must formally organize by the election of a president, who shall be a director, a treasurer, who may or may not be a director, a secretary, who shall be a resident citizen of the Philippines, and such other officers as may be provided for in the bylaws. The President. The President must be a director of the corporation. The powers of the President of a corporation are vested in him by law or by the laws. Otherwise, he has no power over the corporate property and business than has any other director. However, he may be given actual authority to make particular contracts or to execute conveyance, borrow money, execute mortgages, and do other acts. By the charter and by bylaws, resolutions of directors of their informal acquaintances. The second corporate officer is the treasurer. The treasurer of the corporation may or may not be a director. He or she is the proper officer and the only proper officer in the absence of express provision to the contrary, to receive and keep the money of the corporation and to disburse them as he may be authorized. When it comes to the secretary, he or she must be a resident citizen of the Philippines. It is generally its duty to make and keep corporate records, to make proper entries of the votes, resolution, and proceedings of the shareholders and directors in the management of the corporation, and all other matters required to be entered in the records. The secretary is the ministerial officer who cannot bind the corporation unless he or she is authorized to do so. The other officers, the bylaws of the corporation may provide for such other officers and agents as may be necessary and convenient considering the nature and needs of the business. Their compensation is provided for the bylaws and the board of directors in a suitable manner. And we must note and we remember that one person may hold 2 or more positions concurrently when it comes to different officers, except that any 2 or more position may be held concurrently by the same person, except that no one shall act as president and secretary or as president and treasurer at the same time. After the election of the directors or trustees and officers, it should be reported, and it is the Chapter 25 of the Corporation Law. Within 30 days After the election of the officers, trustees, and directors of the corporation, the secretary or any other officer of the corporation shall submit to the Securities and Exchange Commission or the SEC the names, nationalities, and residence of the directors, trustees, and officers elected. And when there are no election happen, the reasons therefore shall be reported to the Commission within 30 days from the date of the scheduled election. The report shall specify a new date for the election, which shall not be later than 60 days from the scheduled date. If no due date has been designated, or if the rescheduled election is likewise not held, the Commission may, upon the application of a stockholder, member, director, or trustee, and after verification of the unjustifiable non-holding of the election, summarily ordered that an election be held. The Commission shall have the power to issue such orders as may be appropriate, including either directing the issuance of a notice stating the time and place of the election, designated preceding officer, and the record date or dates for the determination of stockholders or members entitled to vote. Notwithstanding any provision of the Articles of Incorporation or bylaws to the contrary, the shares of stock or membership represented at such meeting and entitled to vote shall constitute a quorum for purposes of conducting an election under this section. Should a director, trustee, or officer die, resign, or in any manner case to hold office, the secretary or the director, trustee, or officer of the corporation shall within 7 days from knowledge thereof report in writing such fact to the Commission. Lastly, Section 26, the disqualifications of a director, trustee, or officer. A person shall be disqualified from being a director, trustee, or officer of any corporation if, within 5 years prior to the election of appointment, as such, the person was convicted by final judgment. Meaning, if that candidate was, for example, the election will be on September 2020. And for that specific candidate, he was convicted by final judgment January 2015. So, nangyari na to 5 years. Kasi January siya na-convict and September 2020 yung election is over na ng 5 years, which is qualified pa siya. But when he was convicted by final judgment on December 2015 and the election is still September 2020, he will disqualified. If the candidate convicted by final judgment of an offense punishable by imprisonment for a period exceeding 6 years for violating Republic Act No. 11232, otherwise known as the Revised Corporation Code, and for violating Republic Act No. 8799, otherwise known as the Securities Regulation Code, found administratively liable for any offense involving fraudulent acts and by a foreign court or equivalent foreign regulatory authority for acts, violations, or misconduct similar to those in paragraphs I mentioned earlier. The disqualifications that the Security Exchange Commission or the Philippine Competition Commission may impose in its promotion of good corporate governance or as a sanction in its administrative proceedings. And that's all. Thank you.